BBI Law Group, and welcome you all for joining our weekly immigration conference call with BBI Law Group, PC. What we do in this conference call is generally we provide latest updates in business immigration law and other aspects of immigration law, family-based and other aspects of immigration law. And then after briefly discussing what we think of that law, what are the impact of particular changes in law or anything like that, and then we raise a Q&A in the end of the topic and everything. But as going on this week, we did not have too many updates basically, except for a small or a slight amendment by the President for the proclamation order that has been issued on June 22nd, 2020, restricting several non-immigrants and immigrants entering into this country until December 31, 2020. Besides that, there are no other major updates. Basically, everything is going on well. And we all know that 2021 CAP filings have been completed by June 30, 2020. And hopefully, we are hoping that USCIS might open up a few more slots for the cases that have not been selected in the lottery, basically, because we are assuming that there will be many cases that may not have not been filed in the CAP due to the COVID-19 and other reasons, basically. So we're looking forward to that. We do not know because there's no timeline when they're going to open the CAP or anything like that. But we may hear from them as soon as possible and everything else. And second, basically, I would like to tell you is this, that is, during this call, whatever we discuss is just for the informational purposes or educational purposes only. Nothing, what we tell, what we say, it does not constitute any legal advice, basically, between us and the hearing parties. And also, any information that has been shared or discussed in this particular call can be used or disseminated for public purposes in various medium and forum, basically. And would like to let you all know that. And so anything discussed in this particular call is not protected under the attorney-client privilege. Therefore, kindly try to keep your personal facts as confidential as possible while you're asking me the questions in the Q&A session and everything. And now, as you said, there are not many updates basically in the immigration law, especially in the corporate business sector, except that a slight modification has been made to the proclamation order that has been issued on June 22nd, 2020, and basically they made it even more narrow or interpretation for the applicability. Basically, who actually can apply for a visa abroad and enter into this country in those particular categories and everything. Now, as we said, that initial interpretation, what we stated in our previous calls and everything has not changed anything pursuant to this amendment, but the only thing is that whatever the loophole we expected that we may be able to see that basically even that has been closed. Therefore, now we know that certain categories of certain class of people which are trying to enter into this country, that is who are an H1B or H4, who are an L1 and L2 and H2B visa and certain J visa people holders will not be able to come into this country until December 31st, 2020 if they do not have a valid visa till as of effective date of this particular proclamation order, that is as of June 24, 2020, basically. So there's nothing much happening except these two things. Basically, what we're looking into is basically is that H1B CAP has been completed, and as of June 30th, I think all the employers might have should have submitted their H1B filing, CAP filings basically, and we assume that whatever the CAP members that have been not utilized in the initial selection process, as per the USCIS guidelines, we are hoping that they'll get back to us and hopefully open a few more slots for the CAP cases, and they provide again 90 days time to submit those cases basically. If there's a possible, if the USCIS did not receive the petitions as per the required numbers for the CAP basically, and if that happens basically, obviously the people who are in the line right now in the whose status are showing submitted and everything may change to selected basically, and once it changes to selected, the 90-day time frame will kick in over there. That one thing which I would like to tell all of you is please keep reviewing your accounts, see basically if any changes are being made to any candidate information that have been submitted for during the registration with the USCIS or not. besides that, that is not much to discuss today. So what we are thinking is basically is that our call will be very short today for 30 minutes, and I'm going to open for Q&A with the next few right now immediately, and I will be discussing for next 15 minutes all the questions posed by the audience here and answering those calls. When is it possible to open the Q&A today? Yeah. Thank you.
Q&A session has started.
And anyone who's on the call, if they have any questions, please feel free to come out of the Q&A line and pose a question to me. I'm very happy to answer, basically. As I said, this call, we do not have many updates if it comes to the immigration law. Not major changes. Everything is continuing as it is, basically. We all know that now. July 1st has been passed also, and other things are going on. Please, next caller, please. Whoever is on the queue, please pose your question, please.
Yeah, can you hear me?
I can hear you.
Okay. So I'm actually on H1B, and my wife recently went to India, like 3-4 months back.
Okay.
She went there with my daughter. My daughter is a US citizen, and they want to come back to US, but my wife doesn't have a visa stamped yet. So with the recent law that was proposed, can they come back? Where if my wife gets the visa before December, can she come back? Because my daughter is a US citizen and she still has her e-visa, but it will be expiring as well come December.
Your daughter should be able to come back to US anytime because she's a US citizen. However, your spouse will not be able to because she doesn't have a valid visa at the time of proclamation order has come. Even if she obtains a visa, basically anytime between December 31st and today, if the consulates have opened, still she will not be able to travel to December 31, 2020 because she falls into the category of the individuals who have been actually prohibited traveling into this country.
Okay, because my daughter is little, she's like only 3 years. So, and since she's a US citizen, can we send in a request to the immigration office?
You can always make a request to the Department of State to permit her to travel to the US, and Department of State should consider that waiver basically. But it's a long process, and I don't know whether they will even encourage those kind of applications basically, unless it's very, very important and urgent, basically.
Okay. You know? I have one more question. Can I go ahead, or should I?
Yes, please. Please go ahead with your question.
Yeah. So the second question is related to H1B. So I was with employer A till Feb of this year, and employer A filed for my H1 extension. They got the approval till 2022, but I changed to employer B, and with employer B I have till 2022 as well. But employer B is starting to lay off people. So my question is, can I go back to employer A since my H1 was approved with employer A and it's till 2022 as well?
Yeah, if it is still, if you have not withdrawn your H1B and if your employer is willing to take you back into the same position, basically, right? Same position, same location where your work location is and everything stated in the H1B petition, then there should not be any problem. We should be able to move back to employer A without any problem.
Okay. The only clause is that it shouldn't have been revoked.
Yes, the H1B should not have been revoked. Basically, if it has been revoked, employer A, if you want to go back to employer A, they have to file transfer again from employer B. You know?
Okay. Thank you.
Yeah, you're welcome. Next caller, please.
Hi, Bhanu. Thank you for considering my case. So my case is like in July 2017. My company, I have I-140 approved from company A, and my extension was filed. We got RFE with respect to wage 1 at that point of scenario. And in the December, because it came as a wage 1 query, we thought that I may lose the H1. So I asked the company B to file my H1 transfer, but my I-94 was expired, so they filed it in the month of February as per they had some processes. And we responded, the company A responded to Sheila Murthy, my case, the RFE, and we got a NOID as a not final decision, as a final kind of letter that we will be NOIDing. If you have anything to reply, you can reply. In the meantime, where I was working, that was a company C, that was a tier 1, they filed my transfer. So at that time, I had company A, B, C, 3 2 transfers and 1 extension file. I got my company A approval in the month of April, and company C's approval, we got it in the month of June, and company B got it in the month of August. So all 3 got approved one by one. I joined the company C in the month of August. And that was all were valid. Company A was valid till 2019, and company B and C got B got up to 2021, and C got up to 2020. Now my problem came in 2019. My wife went for a DL, so that showed my current, which was company C's I-94. Now I am not working with company B, which was in the center. That got approved up to September 2020, and I'm not working with them. So how do I handle this situation? Nobody is withdrawn.
Make sure that if you're working with whom you're working with, employer B?
Employer B, employer C. I'm working with employer C now.
You're working with employer C. If you're working with employer C, take a letter from the employer C that you're working with them. Make sure that she carries your H1B approval notice and everything to the DMB, and provide that this is the actual approval notice through which he's working. Therefore, what happens is basically that if the system does not show anything, what DMB does is basically they send an email to the USCIS and verify whether this I-797A is valid or not. And if they confirm that it is valid, then they should be able to issue.
She got the driving license. Sorry, my actual question come like, when do I file my extension? My extension is due
whenever your employer sees I-94 is expiring within 180 days of its expiring.
Okay. I don't have to worry, right? In company B, as per USCIS, it is September 2020. But
no, you don't have to worry because you're working for employer C right now. So employer C's I-94 will govern basically.
Okay. So I don't need to inform USCIS, call them and say that I'm working with C or something like that. Nothing from my side.
Nothing like that.
Okay. Thank you. I appreciate your help, and that's all from my side.
You're welcome, sir. Yeah. Next caller, please.
Hi, Bhanu. Good afternoon.
Good afternoon.
Yeah. So basically, I'm working with one of C company. So last year my H1 was approved, and it's the validity period is 3 years. This year in January I came back from India with the stamping. So unfortunately, by mistakenly, my H1 was revoked by my company. So after 1 month they realized that they applied NPT in the month of April. Last week I got a NOID stating that maintenance of status so for this candidate, you guys revoked H1 on February and you guys are applied NPT on April. So justify this time period, maintenance of valid maintenance of status and
is it beyond 60 days?
No, it's not in beyond 60 days. It's they applied in maybe 55th or 56th day. They applied, and query includes the specialty occupation. These two, my question is how complex in this situation? What are the chances of approval? If it's denied, what are the possibilities I have right now?
See, I do not know. The complications can be differing and varying based upon the case to case, basically. See, I do not know the facts of your petition, exactly what they have done, what they have filed, and everything. Especially, you said that you got an RFE for the maintenance of status as well as for the specialty occupation. Okay. For the maintenance of status, basically, yes, we can basically, if it is filed within 60 days of your withdrawal, basically, and I do not know exactly when they send the revocation, exactly what is the date they mentioned your last date of employment and everything in it. If you look into those things, basically, if it is within 60 days, then you don't have to worry about. I'm sorry?
The exact dates are February 19th, they revoked, and they applied NPT on April 24th.
Yes, sir. But when did your employer send the letter of revocation?
February 19th.
They sent on February 19th. Okay.
Yeah.
If they sent on February 19th, and if they refile on April 24th, you should be okay, basically, because your employer should be able to make an argument. Sorry, February 19th and April?
24th.
Oh, then it's beyond 60 days, right?
It's March 24th, sorry, March 24th. Sorry.
Yeah, if they filed on March 24th, then you're okay. But if they filed on April 24th, then you're not okay. Basically, it's beyond 60 days. Okay?
Okay. And
if they file it on March 24th, then that maintenance of status should not be a big issue, basically, because your employer should be able to make an argument about the 60-day grace period and then rehiring you. And that stuff, they can make that argument, and I don't see any problem with that. Whoever the lawyer is, that lawyer should be able to make that argument very successfully. I don't see any problem. If it comes to specialty occupation, it's a position-specific RFE, basically, right? And so it's very difficult for me to answer on that unless I review the file in entirety, basically. And then I can basically give my opinion, what are the chances and what are the likelihood of complexities you'll be facing in responding to the RFE and everything. But what you're telling me is basically is that if you look into it, I'm not really concerned, because I think both issues should be able to be addressed successfully. Okay.
And if worst case, if it's denied, what are the chances to come back? They need to apply again visa, right? So
they have to apply again. You have a valid visa, luckily, basically, so they need to apply again. You have to leave the country, and then because the problem is, even if you have a valid visa, that visa will not be valid for you to come back into this country, because they can only file for consular processing because you don't have a valid status at the time of filing a new H-1B petition now. Because at that time you may qualify for 60-day grace period, but now you may not qualify for 60-day grace period. Because you don't qualify for 60-day grace period, it's very, we do not know whether USCIS will issue I-94 to you or not. We can make an argument for the I-94, but we do not know whether they'll issue that I-94 for you or not. If they don't issue that I-94 to you, then obviously you have to go for stamping again, because that H-1B will not get into effect unless you go for the stamping of that H-1B, basically. Okay.
Oh, okay. So I just got to know that they applied, they responded, they applied NPT on April 21st. That means it's beyond 60 days, 62nd day.
Yeah, that's the reason why they issued that RFE. That's why I was surprised why they're asking that question right now, because it's beyond 60 days. That's why. That's where probably, even if the H-1B is approved, very likely that you will approve a consular processing because of that.
So then again, I need to go stamping, or if I step
yes,
out?
you have to go for stamping. You have to go for stamping. You just can't step out.
Okay. The current visa won't be valid in that case?
No, it won't be valid in that sense, basically, because that H-1B has to be activated in the consulate. That means you have to go for the stamping in the consulate.
Okay. Thanks.
Next caller, please.
Yeah. Hi, Bhanu. Good evening.
Good evening.
Yeah. My question is actually for my wife. I filed a H-4 EAD in November 2019, and till now, the status is still showing the case is received, but after that, there is no update. So, is there any way that I can expedite, or
you can actually call a customer service center and raise a request. Basically. Okay. Did she complete her biometrics?
Biometrics, I haven't done that actually.
Yeah. I mean, an H4 will not be approved until the biometrics are completed, unfortunately.
Oh, biometrics we are requesting because her I-797, she don't have I-797 because all the H4 she came with that stamping only.
You said that she came back in November 2019 in this country, right?
No.
What's going on?
I applied H4 EAD.
You applied for H4 EAD basically. Okay.
Yes.
You're talking about H4 EAD, sir, basically. Okay.
Yeah.
Yeah, you can call the customer service center, sir, basically.
Yeah, I called them. So what they told that I cannot expedite, but they told that should be some reasons for that. So will I be eligible to apply to expedite on that one, or is it?
I mean, sir, as I said, there should be certain circumstance basically to expedite any request that meets the criteria for the USCIS to consider the application under the expediting process basically. Okay, and it's completely discretionary released by the USCIS basically. There's no standard set of rules that this is what is required to qualify somebody's petition for the expedited processing by the USCIS basically. Okay, it is based upon the officer to officer, case to case. It just varies basically. Okay, sometimes people will be lucky. Sometimes we get lucky. They'll accept 4 or 5 cases from us for expedited processing. Sometimes we don't get lucky. They will not accept anything from us for the expediting process basically. Okay, and most of the times we may see the same or similar conditions or similar requests people have made basically because they don't have anything else to make. But still, it is what it is basically. So my advice is basically to you is basically yes, you can make expedited request. Write a letter to them. Whether they will consider that or they won't consider that, it's something depending upon the offices there. And nothing much we can control on that. But if it's beyond the processing, times, and if they don't give you any information on that, then basically you can approach a local congressman or a senator and ask them to send an email or ask them to contact the USCIS basically, explaining that this case was beyond normal processing times basically. Okay.
Then I need to reach out to the senator for that because currently the processing time is showing from January 2020, but I have applied in November 2019. Actually.
Yeah, then I think talk to the USCIS, tell them that it's beyond the normal processing time and why it's taking so much time basically. If they don't answer you properly, then I think the best approach is reaching some congressman or senator and asking them to reach out to the USCIS basically why this case has been pending more than normal processing time.
Oh, okay. Sure. Thank you so much. And just a question on that. My child passport is expiring in a couple of months, but actually DC office is closed due to COVID. So will there be an issue if we want to travel?
Yes, sir. It will be an issue. It will be an issue basically. I know that DC consulate services are being open for emergency situations like this. You should reach them out.
Oh, is it open? Can I?
It is open for the passport. Yes. For passport renewals, it's open. Yeah. Just talk. You need to okay.
Okay. Thank you so much, sir. Yeah.
Right. Next caller, please. Hello. Yeah. Next caller, please.
Can you hear me?
Yeah. I can hear you.
Yeah. My name is Ashwin, and I have a valid visa till 2022. My question is, I'm working for employer A right now, and I'm planning to go back to India once the flights are open. And my question is whether I can change from employer A to employer B, being in India, and is there any implications?
Do you have a valid visa in your passport, sir?
Yeah, valid visa is there till 2022.
Okay, but if you want to transfer an employer, basically, you have to file the transfer while you're in the US. Then you can use that visa to come back to US, basically. Okay?
Oh,
otherwise,
sitting back in India, I can't change my employer, is it?
You can't change your employer because what happens is basically that at the time they cannot file for the extension of status in the US because you're not legally present in the US at the time of filing the transfer, basically. Okay? Therefore, that H1B will be approved for the consular processing only.
Oh, okay. So if I get a job also, I can't come back here and apply. Is that not possible?
Not possible unless you go for the stamping again.
Oh, okay. I got it.
Yeah.
Okay, yeah.
That's
Thank you so
what
much.
it
Yeah.
is.
Thanks.
You're welcome, sir. Yeah. Next caller, please.
Hi, Bhanu, can you hear me?
Yeah, I can hear you.
Okay, thank you. Okay, one of my friends, he traveled to India during March, and then he got his visa during March, and then this new rule came in June 24th. So can he travel right now?
You mean to say he has a valid visa? H1, in which category, sir? Is he an H1B?
H1B, but he went for stamping during March, and then he got stamping during March.
Yeah, that is fine, sir. He is fine, sir. Absolutely fine. He should be able to come back if has a valid job and everything.
Yes, he has a valid job, and then he got visa for 3 years, so he can come back right now.
He should be able to come back, sir. Yeah.
So anybody is doing visa after 24th, they cannot travel, is it?
Absolutely.
Okay. Thank you, Vanuga.
Yeah. Right. Next caller, please.
Hello, Bhanu.
Yeah, I'm here.
Can you hear me?
I can hear you. Yes.
Yeah. The thing is, at present I'm in STEM OPT, and my employer had sent, and my H1B got picked in the lottery this year, and my employer had sent my packet on June 19th, and USCIS had received my packet on June 22nd of last month. The thing is, I haven't received my receipt notice. Right now my STEM OPT is coming to an end on July 9th of this year. That is exactly next Thursday. So what my attorney or my employer is saying, I need to apply for cap gap. So for that, when I reach to my university, they are saying I need to have my receipt notice. Unless or until I don't have that receipt notice, they can't apply for cap gap. So is there any chance what if I get my receipt notice after July 9th? So what are the scenarios, sir? Can I still work